Welcome back, everyone, to the Keeping Sports Safe, Safe Sports Speaker Series brought to you by the Canadian Sports Centre Manitoba and Fit Women and Girls. Something our participants will not know is that through the beauty of Zoom and remote work, I actually reside in Ottawa, Ontario. I would like to acknowledge that the land I am presenting from is the traditional unceded territory of the Algonquin people. The Algonquin peoples have lived on this land since time immemorial, and I am grateful to have the opportunity to present in this territory. Today we will be discussing hiring practices with a representative from Pitblado Law, Nicole Smith. She received her law degree from the University of Manitoba in 2012 and became an associate at Pitblado Law in June 2013. Nicole practices primarily in the areas of labor and employment law, human rights, and immigration law. Nicole's involvement outside of work include participating as a board member for the Manitoba Chamber of Commerce, as well as volunteering at organizations which provide access to justice in Winnipeg, such as the Legal Help Center. Please feel free to raise your hand throughout the discussion or put a question in the chat box as we go along, and I will now pass it over to Nicole.
Passionate about this keeping safe sports, and it's sort of a new area for me, but my 4-year-old right now is just getting into soccer. Unfortunately, it's just recently been delayed, as many of you from Manitoba will be aware, but I've really never considered the idea of the importance of keeping sports safe in such detail up until now in my life. And now I can see that it's very much going to be an important aspect of our social life. And it's very important initiative that I want to just say thank you to all of you who to participate and push forward in that initiative, because it's definitely an important aspect of keeping our kids safe in sport. So I just want to speak to you a little bit about hiring practices today, because that's a very good way of keeping the kids safe, athletes safe in your organizations, and really structuring a solid organization staff that can help you move forward and help your organization succeed for many years to come. So let me know if, I don't know if I think Jesse may have mentioned, but please feel free to stop me, interrupt me if you have any questions about any of the slides that I have. And I'm happy to take those questions now or at the end of the presentation. That's entirely up to you. So I would just begin with sort of a summary slide of what we're going to be looking at today when discussing best hiring practices. One important thing for all employers to know it's important to be mindful of the obligations under the Human Rights Code. Every employer in Manitoba and in other jurisdictions across Canada are subject to human rights legislation. In Manitoba, that's the Human Rights Code of Manitoba. For federal jurisdictions, so federal employers, that would be the Human Rights Act. And the name changes slightly depending on the jurisdiction that you're in, but all jurisdictions in Canada have a human rights piece of legislation. We'll also be discussing the skills and knowing the skills and qualifications that you're looking for in a candidate. That's an important piece to hiring a solid incumbent who will, stay with your organization and strengthen it for many years to come. And as well as asking the appropriate questions in the recruitment process. That's a very key aspect of it, of the entire process. And then, of course, there's the privacy rights of candidates, which is a very important piece of the puzzle as well, because recently privacy rights have become very front and center. And so it's important that employers are aware of the privacy rights of not just their employees, but also of job candidates that they're interviewing. And then finally, I'll discuss setting expectations with your new hire, which is another way of solidifying the relationship, clarifying expectations going forwards, and ensuring that you're reducing the amount of conflict in the future between employer and employee as much as possible. So let's begin with the Human Rights Code. Now, of course, the Human Rights Code deals with discrimination, and there's a number of different prohibited grounds that the code deals with. And discrimination essentially means treating a person or group differently because they have or are presumed to have one of the protected characteristics listed in the code. And those include, and I just want to go through them briefly because it's very important. Human rights issues are a very, very up and coming issue in employment generally. And it's very important for employers to be aware of what the protected grounds are, because if you're not aware, it's very possible that there'll be some kind of a subconscious discrimination that may occur without even intending to. So those grounds include discrimination based on ancestry, including color or perceived race, on nationality or national origin, on ethnic background or origin, on religion or creed, or religious belief, including religious association or religious activity, discrimination based on age, on pregnancy or circumstances related to pregnancy, which can be, for example, breastfeeding, gender identity, sexual orientation, marital or family status. And that includes, just as a side note, that includes who you are married to, just not just the fact that you are married, but who you are married to can be included in there. Source of income, so who your employer is, or maybe for former employer, or any kind of income, to be honest. And then political belief, political association or activity, as well as physical or mental disability related circumstances. So that includes reliance on a service animal, reliance on a wheelchair, or any other remedial appliance. And then finally, the last ground is social disadvantage, which more recently I'll get into in a little bit more detail later on in the presentation, but that includes it now as an analogous ground, criminal record. So it's important that an employer is aware that prohibition on of discrimination on these grounds extends to all aspects of full-time, part-time, permanent, casual, or probationary employment. But it also applies, and many people aren't aware of this, but it also applies to paid or unpaid or volunteer work, and including recruitment. So that means in the entire process, from the job posting to the application forms to the interview. So that can be considered discrimination in employment if there's any discriminatory action that happens in the recruitment process. So as you are likely aware, there's occasions where an employer may have a bona fide or reasonable job requirement that results in treating people differently on the basis of one of these characteristics listed in the code. And that is certainly contemplated by the code and the Human Rights Commission. And in such cases, the employer must be able to show that the requirement for this job position is connected to the successful performance of the job and has been established in good faith, and that it's reasonably necessary for the safe or efficient performance of the job. So that requires employers to sort of take a step back and determine and take a hard look at all the requirements that they are including in this job position and that they're recruiting for. So an example that the Human Rights Commission gives is a job position for delivery driver, for example. So this delivery driver position identifies the requirement for a Class 1 driver's license. And this, of course, necessarily excludes persons with certain disabilities who are not able to obtain a driver's license. Now that would be considered a driver's license, or a class 1 driver's license would be a reasonable job qualification for the position of driver or delivery driver. And so that would not likely be considered discrimination by the Human Rights Commission should a claim be made. So in general, the best practices regarding human rights accommodation is in recruitment is to offer and provide accommodation for the interview or the test that you may have an employee undergo. So for example, it's first and foremost important to make the test accessible. So have it in a building where there are wheelchair ramps if needed. And another example is potentially being able to accommodate a candidate if they, for example, have dyslexia or ADHD and they need to take the test in a room all by themselves. That's certainly not uncommon request. And so it's generally a good idea or a best practice to be able to provide that kind of accommodation to your candidates, to any job candidates who may be applying for your position. So moving on to my next slide, which is knowing what you're looking for. We first want to tackle advertisements. So choosing the appropriate forum for advertisement is an important first step in the recruitment process. Now, for coaches and athletic support positions, I'm sure all of you know even better than I do where an appropriate forum for those kind of positions would be, but I could, as a suggestion, university or alumni community job boards are, I would imagine, an appropriate forum to find individuals who are passionate about sport, which is what you want in your organization. But what I'm really getting at there is it's important to avoid generic sites that tend to attract people that are simply looking for a job, and they may in fact just be looking for any job or just be applying for any job because they're legally obligated to. So for example, anyone on EI is obligated to be applying for jobs and they have to show that. Excuse me. And so those generic sites tend to get a lot of people who are legally obligated. So another important step in knowing what you're looking for is creating and making sure that your position or as an organization, you're abiding by your human rights obligations, is job descriptions. Writing job descriptions is an extremely important step in planning staffing programs. They really form the foundation for many important processes like job postings, recruitment, selection, and they really help in setting expectations for compensation, training, and performance management. So an awareness of expectations for employees also helps employers properly evaluate their performance in the future, which is one of the main purposes of a job description as well. So, and then one thing I wanted to just mention too, another benefit of a job description is stepping ahead maybe a few years, or depending on the relationship, but if an employee has to be discharged for just cause, the employer, it's important to have a job description because that employer will have to prove that the discharge resulted from failure to perform those duties contained in the description. So having a concise and well-written job description can be invaluable in that situation. So the first step in ensuring an equal opportunity in the hiring process is to review the job description to really identify the essential job duties of the position. So that includes the criteria, skills, or qualifications that are necessary to perform those duties. And really, it's important that the required qualifications for the position are distinguished from the preferred qualifications. And in that regard, So for example, if you're hiring a position that deals with, public in a certain community where there's a high Filipino contingent and you'd like someone who speaks Tagalog, well, that's fine, but it should be a preferred qualification, not necessarily a required qualification. And it would be a good idea to include that or to note that in the posting, because you could potentially really be limiting the amount of candidates that apply for the position when it's a position, or when it's a characteristic that's not truly required. And it could even get you in hot water with the Human Rights Commission. So, excuse me one moment. To avoid unreasonably restricting employment opportunities for a group with characteristics listed in the code, it's important to ensure that any standards, policies, or rules that are adopted are first and foremost rationally connected to the performance of the job, that they are adopted in an honest and good faith belief that they are necessary to the fulfillment of a legitimate work-related purpose, and that they're reasonably necessary to accomplish the legitimate work-related purpose. So an example that I can give is when a job description is written for a hostess at a restaurant, for example. It may identify that, or let's say the employer identifies that an undergraduate degree is a required qualification simply because the employer feels that a high school student wouldn't be mature enough for the job. Well, in that situation, if a human rights complaint were to be made about that by let's say a high school student who was wanting the position but refused because they didn't have a degree, well, that could put you in some hot water with the commission, because the employer didn't fully consider whether a degree is in fact an essential qualification, on whether there are other ways of recruiting the candidates with the desired maturity level. Okay, so determining and asking the appropriate questions. I'm not going to go through what are appropriate questions. I'm sure a lot of you can kind of figure that out based on the position that you're recruiting for, as well as the organization that you're recruiting for. But it is important to determine the appropriate people for the hiring committee. So the interview team can include the relevant supervisors and managers. It can include key internal customers or stakeholders, as well as important potential colleagues. What is important is to involve someone who really understands the key duties of the position, and really ideally someone who will be working directly with the incumbent who's hired. Excuse me. So, as a bit of a tip, I definitely suggest having a list of interview questions that you plan to ask each of the candidates, and most importantly, making sure that those questions are consistent among all the candidates. Now, you also have to, of course, ensure that the interview questions comply with the code, with the Human Rights Code. And to do that, you want to take care to make sure that the interviews are really only to get information about the qualifications and the job requirements needed for the hiring decision. So that really means that you shouldn't be asking questions about marital status, excuse me, about whether a candidate has or wants kids in the future, how old they are, where they're from, or their country of origin. Now, this has been proven. The importance of this has been proven in a fairly recent decision of the Ontario Human Rights Tribunal, that simply asking improper questions is in fact enough to prove discrimination. So it is important that you really ask thoughtful questions that you've prepared in advance, ideally.
Nicole, I'm so sorry to interrupt. Can I
Yep.
ask a question on this point?
Absolutely, yes.
I'm thinking about the kinds of questions we might ask to uncover beliefs or background with respect to safe sports. So do you have any guidance on sort of how deep we can push into, for example, the background of a candidate and their experience in safe sport issues? Like, can we ask straight out if they've ever been involved in a complaints process as a respondent, for example, or is that sort of thing completely offside?
You can, if you word it like that, yes, you certainly can. So I get where you're coming from. I would certainly stay away from asking about any religious beliefs or religious organizations that they're involved in, making the assumption that that will lead to some kind of danger or risk. But you can certainly ask about past employment and their disciplinary record in that employment. Because if they've had issues in the past and you ask about that, then that's something that they need to answer and they need to respond to. I hope that answers your question.
Yeah, thanks very much.
Great. So the other aspect or another important piece in recruiting and doing it in accordance with the Human Rights Code and in a manner that's going to be very fruitful for your organization are pre-employment checks. And those are also a fairly controversial issue these days, but they're extremely important nonetheless. In Manitoba, excuse me, they are particularly important because we specifically have legislation that governs background checks. And I understand that there are certain members of the audience that are not from Manitoba, so you should definitely take a look to see if there is any legislation that covers background checks in your jurisdiction, because it certainly could put you in hot water not knowing what it is that you can and can't do. So in Manitoba, anyhow, background checks or reference checks could mean verifying a candidate's educational credentials or getting feedback from former bosses. That's generally the most common. Excuse me. And any background checks or reference checks really should relate to the essential positions of the job, or sorry, essential duties of the job. And you really need to stay away from soliciting any information about prohibited grounds of discrimination. So things that you can ask about include the candidate's dates of employment, their roles and responsibilities, their disciplinary record, even attendance to a certain degree. Now, what you want to stay away from there is making any decisions about a candidate because they had issues or health problems and they had to miss a significant amount of work in their previous employment, and then making the assumption that that's going to happen in the future. That's something that could get you into hot water with the Human Rights Commission. So you can't, although you can ask about attendance, I wouldn't base any decisions on any attendance that was caused by a disability. And then, of course, you can ask about the candidate's strengths and weaknesses. Sorry, excuse me. So, as I mentioned, I'm going to get into the legislation governing reference checks or background checks in a little bit, but I also wanted to get into other types of checks that are available in pre-employment, including the criminal record check. And in Manitoba, as I mentioned previously, it's not a criminal record check is not an explicit prohibited characteristic listed in section 9(2) of the code, which is the section that lists all the prohibited grounds. But the Human Rights Commission does accept complaints of discrimination based on a criminal record. And in a very recent decision, it has concluded that the code allows for the inclusion of a criminal record as an analogous ground. So we can expect to see in the future a lot more claims or complaints to the Human Rights Commission based on discrimination on the basis of an individual's criminal record. So to this end, employers really need to be careful when they're requesting criminal background checks. An employer can make this request if it's based on a bona fide and reasonable requirement or qualification for the employment. So I would imagine that a lot of members of the audience here today are dealing with potentially hiring, athletic support positions that may be dealing with children. And so that very well could be considered a sufficiently bona fide requirement for the pre-employment check. Now, what is a little bit more difficult is determining if a charge or a conviction is sufficiently related to the employment or the service to influence the employer's decision to hire or not, because the Human Rights Commission has published a policy on its website, and I recommend that you definitely go look for that. If you have requested a criminal record check and it comes back from a candidate, excuse me, comes back as a conviction on there. So that would be something that you definitely need to then take the next step to determine whether that conviction is sufficiently related to the employment to allow you to not hire that person. So at the end of the day, it is the onus of the employer or the service provider to establish that the existence of a criminal record or a charge or conviction is a reasonable disqualification. And I would say that in the world of athletic support, it would be, any kind of assault conviction, especially if it were related to a minor, any kind of sexual assault, uttering threats, that sort of thing. And then to that end, there is child abuse registry checks in most provinces, certainly in Manitoba, and they're not available to just anyone. Not just anyone can access the child abuse registry, but it if the position, excuse me, if the position is involves or may involve the care of a child or permit unsupervised access to the child or a child, the employer may have the ability to apply for access to determine if a person is listed on the registry. I apologize. It's very dusty in my house today. So that goes as well for the adult abuse registry check. Again, an employer may have the ability to access it depending on the position, whether it's required. What I wanted to briefly talk about, which I haven't put on the slide because I definitely don't recommend doing as a pre-employment check, but it can be an option in very narrow circumstances, but those are drug tests. So an employer should be very cautious in using any kind of drug or alcohol screening tests prior to an interview. This is a very, very controversial area. It's very gray in the law right now, what is allowed and what would be considered discrimination. And it certainly may open the employer up to allegations of discrimination against a person with a drug or alcohol dependency. So, excuse me, the employer must be able to justify that the test is necessary, and it's reasonably necessary due to a real and significant workplace safety concern. but also that the test is reasonably necessary at this pre-employment stage. And generally, the courts have said that pre-employment testing are not a good idea, except for, and they may be justified depending on the circumstances, for some safety sensitive positions in the work environment where there's been a history of substance abuse. So that some examples, or most obvious example of that would be like construction. If someone's working a very heavy piece of equipment and there would be significant danger involved should this person be using alcohol or have alcohol or drugs in their system while at work, that would potentially could justify the use of pre-employment testing. But even then, it's as I said, a very controversial issue and potentially would result in a human rights complaint. Now, this is also, of course, because an addiction or whether it be drug or alcohol is considered a disability under the code. And so refusing to hire someone because of an addiction can be considered discrimination. So that's another drawback to any kind of drug test that's done as a pre-employment check, because even if it comes back as positive and this person had drugs or alcohol in their system, that does not necessarily mean that you as the employer don't have to hire them. You would certainly have to look to see if there are any other positions that this person could do that wouldn't be as safety sensitive. And also the other aspect is, doesn't necessarily prove that this person is going to be, who's not even working for you yet, that this person is going to be showing up to work either with alcohol or drugs in their system. So a good example of this is for example, an administrative assistant who is not hired because her reference discloses, or her resume or references disclosed that she attended an alcohol rehabilitation program. If her employer in that case should seek information about her reliability and work performance and really assess whether or not she's qualified to perform the duties of the position, rather than just assuming that she's going to relapse without any information to indicate that she's continued to struggle since participating in the program. So as I said, you really have to be careful about those drug tests. And generally, I would recommend against trying any kind of pre-employment testing. So let's move on to employee privacy rights, because this is a big area and one that's kind of in the forefront these days regarding law, and it certainly applies to job candidates in the recruiting process, as well as to current employees. Now, in Manitoba, provincially regulated private sector employers are not subject to specific provincial privacy legislation, excuse me, concerning the collection, use of, and disclosure of employee personal information. But that certainly doesn't mean that employers do not need to be concerned with protecting employee privacy, because there is also common law tort of intrusion, which is essentially a privacy breach that an employee or potential candidate could bring before a court to sue you in a lawsuit. So just so you're aware, the test for the tort of intrusion upon seclusion, which is the common law tort of privacy breach, includes that the person would have to show that there was an intentional conduct, that there was an invasion of private affairs without lawful justification, and that there was a reasonable person would regard the invasion as highly offensive, causing distress, humiliation, or anguish. So depending on what the privacy breach is, that may not be all that difficult to make out. So it's certainly something that you need to be aware of. Now, federally regulated private sector employers. So those are employers excuse me, in specific industries, which are regulated by the province, by the feds, as opposed to the province. And I just wanted to stop there to kind of clarify what that means, because a lot of people don't actually know whether their employer is regularly or provincially regulated. And I can tell you, in all likelihood, you're provincially regulated, especially in the realm of athletic support. That's generally provincially regulated. Federal industries include banks, aviation, trucking, railways, that sort of thing, things that are a little bit more national in scope. And it certainly doesn't matter where you obtain your funding from. That does not dictate whether you're provincially or federally regulated. But nonetheless, my understanding is there could be some federally regulated private sector employers here. So you should be aware that you are subject to the Personal Information Protection and Electronic Documents Act, which is PIPEDA. And it applies to personal information of employees that's collected or used and disclosed for employment purposes. So public sector employees, so that's more government employers, have specific statutes in Manitoba as well as federally. In Manitoba, that would be the Freedom of Information and Protection of Privacy Act, as well as for certain employers, FIA may come into play, which is Personal Health Information Act. And then federal employers would be the Privacy Act. So these specific statutes dictate what needs to be observed whenever personal information is collected and used and disclosed. So when privacy laws do apply, the employer really must observe a general principle that first and foremost, that which is collected is there's really no more personal information collected than should be, and no more that should be used or disclosed than is necessary to accomplish the purpose for which the information was collected. So that means that for each question on your job application, you as the employer should be prepared to identify a particular purpose for that question, ask if the question relates to that purpose, and also whether the purpose could still be satisfied by a collection of less personal information. And just so you're aware, personal information is very broadly defined. It's defined as any information that's about an identifiable individual. So it's a very broad term, and that would apply to most job applications, resumes, etc., information that you would collect in the process of recruiting staff. So very important for employers to be aware of what privacy legislation applies to them, as well as what that privacy legislation means for them. So, as I mentioned previously, background checks, it's really essential as an employer to know and understand the limits of what information you can and cannot collect about your job candidate, and to really know how it should be handled upon collection. And this is, of course, as I mentioned, because background checks are governed by privacy law. In Manitoba, pre-employment inquiries or background checks are governed by the Personal Investigations Act. And to the extent that an employer makes inquiries with a third party to obtain information about prospective hires in connection with employment applications, that's where it applies. So what it's important to know is that the Personal Investigations Act requires the employer to obtain a prospective hire's consent, which is oftentimes implied when they give you the references or the information, their contact information for their references. But as I mentioned further on the slide, it's always a good idea to get that consent in writing, just so you can prove that in the future if need be. But so that consent's required before you actually contact the third party to make inquiries. The Act also prescribes requirements as to the form and the manner by which the consent must be obtained, and provides applicants a right to request a factual record of information supplied by the other third party. So that really comes into play with respect to giving references, which I'll mention in a little bit as well. But right now, we just want to focus on the recruiting process. So the information that you collect it's important that it's reasonable in its scope, use, and disclosure. So that means that when you are performing a background check, you really want to make sure you, first of all, don't collect any more information than you need or that is relevant to the job position. You really want to use information only for the purpose for which it was stated to be used. So for the employment recruiting process. You also need to make sure that you properly store and protect the information so that it's only accessible to those to whom it's relevant. So you shouldn't be leaving this information out for your whole organization to view, because that certainly could be considered a breach of privacy. And then make sure that all the personal information that you do collect about a potential employee is available to them to view and to check its accuracy, because they have the right to do that. And then finally, you want to make sure you destroy or delete the information once it's no longer necessary or needed. So all of these tips really do apply as well for when you give an employment reference, because the Act, the Personal Investigations Act, dictates that you can't make any reference to an individual's race, religion, ethnic origin, or political affiliation, any of the protected grounds under the code, unless that person, the candidate, is voluntarily supplied that information to you first. So another important thing to note about the Act, the Personal Investigations Act, is that you can't make a reference to any other adverse factual or investigative information that is more than 6 years old. And that the reason for that is because of the statute of limitations. Most things are out of date, out of time after 6 years, and they're supposed to be considered kind of in the past. So unless that information is voluntarily supplied by the candidate or the employee or former employee, or you really want to make sure that you may also be required to disclose the information. Sorry, that's what I wanted to get at. You want to make sure that what you're disclosing is accurate, because you may be required to disclose the information that you gave to the third party under the Act. So as mentioned, best practices are really, it's important to obtain written consent before doing any kind of pre-employment checks on a prospective employee. And that includes consent for the reference check, but also criminal record check, child abuse registry check, adult abuse registry check. So important to make sure you have that written consent in case it's useful in the future. So I just wanted to briefly discuss the risks of non-compliance, because as I said, privacy issues or privacy complaints are becoming much, much more common these days. I've dealt with a number of them in the employment area, and people are taking their privacy very seriously. And so one option for an employee is to make a privacy complaint. So in Manitoba, that would be to the Ombudsman's office, and that's really for public sector employers. So if you're an employee of the public sector, then you have that ability, because the Ombudsman's office enforces FIPA, Freedom of Information and Personal Protection Act, and then FIA, as I mentioned before, Personal Health Information Act. And federal employers, their employees of federal employers can make complaints to the Office of the Privacy Commissioner. So in each of those circumstances, either the Ombudsman's office or the OPC conducts an investigation, and they release a non-binding recommendation. So in any of the complaints that I've seen, it's never been awarding damages, like monetary damages. It's basically just recommendations about how the employer should be improving their processes to avoid any privacy breaches in the future. That being said, with respect to the Privacy Commissioner's Office, the Commissioner's Office or the complainant can, in fact, sort of elevate the matter to federal court if they choose, and that in federal court there can be damages awarded. And then, of course, the other option is a privacy lawsuit, which can be brought if there was a common law tort of a privacy breach, or to enforce any statutory torts under Pitblado Privacy Act or other privacy laws. And these laws really contain two types of obligations that you should be aware of. Excuse me, which is obligation regarding how and when personal information can be collected, used, and disclosed, as well as obligations relating to how personal information has to be maintained. And then, of course, the third risk is reputational damage, which very well may be the most important risk of non-compliance with privacy, especially if you're recruiting employees, because people talk. And then I just wanted to briefly discuss setting some expectations, because as I mentioned at the beginning, setting expectations of an employee is really a number one way to avoid issues, problems, conflict in your organization in the future. And to this end, as described before, job descriptions really help ensure your expectations are established and met. And a well-written job description will establish a really solid set of expectations for employers to communicate to their employees. Excuse me. And often in my experience, employees tend to be very grateful to actually see their expectations written down in black and white, so that they know what's expected of them. They know where they may have to improve. And that, as I said, can really avoid certain conflicts in the future and just make your organization run a lot more smoothly. And then secondly, an employment agreement is a great way of setting expectations. Some key advantages to having a written employment contract is that you'll have certainty of terms. Because when an employer chooses not to commit the terms of employment to writing, then in that scenario, in that situation, there's an implied contract between the two parties. And the terms of that implied contract come from a number of statutes in Manitoba. That would include the Employment Standards Code, as well as the common law, which is really a body of cases or judge-made decisions that have previously been decided by the courts. And there's a number of aspects of employment that are contemplated in the Employment Standards Code and by the common law. And it's really important to know what those are if you don't have an employment contract. So one of the biggest hidden dangers of not having a written employment contract signed is that the amount of notice that the employee is entitled to or will have to be paid to the employee on termination. Because if there's no contract, it's implied by the common law. And I can tell you, the common law notice requirements vary from province to province, but in Manitoba, it's generally in the range of 2 to 3.5 weeks per year of service, which is significantly higher than the minimums of the Employment Standards Code. And so a lot of employers are really unaware of what their obligations are when they try to terminate an employee, not for cause, of course. And then they think they can get away with just paying the minimum notice requirements set out in the code, the Employment Standards Code. And then they get a lawsuit or a demand letter from their employee's lawyer that says, no, actually, instead of the 8 weeks of notice that you paid me because I'm a 15-year employee, you owe 15 months of notice. And so that's a huge difference, and something that you can avoid pretty easily by having a written employment contract and setting out those terms clearly right from the beginning, the start of the employment agreement. So as I mentioned as well, there are other benefits of employment contracts that, to clarify the terms, that can really help you avoid conflict in the future. And one of those can be clarifying the amounts of vacation days, sick days, or any other benefits that the employee may have, including bonuses or commission, that sort of thing. Because those are very, very helpful to have out and have in writing, because one of the largest cause of disputes that I've seen or I see in my practice is fights over commission or bonuses that an employee may be entitled to. So having that set out clearly in black and white could really avoid a lot of misunderstandings and save you a lot of money in the long run. And then additionally, a contract can be helpful in establishing a probationary period for an employee, so that they realize that for the first month to 3 months, sometimes even 6 months, they're on probation, and that it's really a adjustment period, or it's an assessment period for both the employee and the employer. Now, that being said, that doesn't necessarily mean that you do not have to pay notice during the probationary period if you do decide not to hire the employee permanently, because under the Employment Standards Code of Manitoba, you are required to provide notice if they've been with your organization for 30 days. So a lot of employers aren't aware of that either, but sometimes setting out clear expectations of a probationary period does simply allow the employee to understand that they're still being assessed. So finally, a contract is really quite useful as well for an employer who wants to protect their confidential information. This is a requirement of employees during their employment with the employer, but what a contract can do can also place a duty on the employee to keep that confidential information past the term of their employment. This is likewise very useful if you're wanting to prohibit an employee from soliciting your customers after they leave your organization, or even wanting, sometimes in certain situations, wanting to compete afterwards. You can include a non-compete clause in your employment agreement that may be able to prohibit that or prevent that from happening. So this will be my only plug for getting a lawyer, I promise, in my presentation. But I can say that having a contract prepared by a lawyer is one of the cheapest ways of avoiding issues with employees, because when you have a well-written contract, it sets out expectations and it protects the employer's interests. And having it reviewed every couple of years or a few years is also a good idea, because the law is very fluid in this area and it changes constantly. And just, sending it to your lawyer to review and say, hey, is this on board with the law as it stands right now, is definitely worth your while. So that's really it for my presentation. And we don't have a huge amount of time left for questions. I apologize, but I am certainly happy to take any questions that anyone has about my presentation.
Sorry, I'll jump in again. Thank you very much for that. I was curious on the discussion around the references. when we are being asked to provide references for a former employee, and I guess part of what I'm thinking about here is there was this case that U of M in the last few years, I think in the music department, where they dismissed someone for some of the kinds of behaviors that we would all be concerned about here in and around safe sport. That person then went to a US school. The US school called University of Manitoba for a reference, and they all they confirm is kind of employment dates, but not the cause for dismissal. And people at that new institution were re-victimized. So like, what is our obligation as former employers when we are called for a reference check? Like, what can we disclose? What must we disclose? And especially in consideration of the health and well-being of people in other organizations where an individual might go.
Yeah, I mean, you can disclose information that's not fraudulent or negligent, and it's truthful. So that's really, I know that's not particularly straightforward because it's a bit gray, but you certainly can disclose employment dates, references to disciplinary records, that sort of thing. Now, that situation with the music teacher is a little bit, it's a little bit odd because he actually won his arbitration that just came out last year. He was awarded almost $300,000 against by the arbitrator that to be paid by the U of M because of and they don't go into details, but because of whatever the U of M said to the University of Berkeley in Boston, I believe. Excuse me. And so he was awarded, he was granted, and the grievance was successful because the university breached his privacy. So, and the decision was mediated. It was a mediation/arbitration. So they don't publish the details that went on in the mediation or whatever was said in the reference. But I assume that it was something that was able to be established to be either an exaggeration or fraudulent or untruthful. And that's where you need to the area you need to stay away from. But as I said, I would look to the Personal Investigations Act, and really what the act establishes is you have to be aware that an employee or former employee that you're providing a reference about is going to be able to or has access to provide to what you said and to what your factual basis was for that. So that's something that you need to be aware of when you're giving any kind of reference.
Chilling for the people on this call, and I certainly don't want to speak for anyone else, but I just, one of the themes that runs through the safe sport idea is that where there is a significant violation, like one of these really egregious behaviors that tends to make the news, is that we don't want someone to be dismissed from Club A and then go to Club B and carry on with these behaviors. And a big part of that is an effective mechanism to share those findings within the system. Do you have any advice beyond just making sure that the records are absolutely crystal clear and entirely fact-based, and then we're pretty good to share?
Yeah, I think that's the basis. You need to start there. Make sure that you're sharing, you don't want to share too much detail either, but you can maybe determine or provide the results of an investigation that may have occurred, but not the details of what happened necessarily, and the basis for your decision to discipline that individual. But as I said, it's a gray area. There's certainly risk to it. And that's why generally we recommend to employers that you want to keep your employment references fairly neutral. And I understand that in this particular area, you're certainly wanting to avoid any re-victimization if that occurs. And I certainly understand that. But then if in that case, you need to make sure that the information that you're providing is factual.
Okay, thank you.
You're welcome. Is there any other questions? And I wanted to let everyone know that if you do have any other questions, feel free to contact me. My contact information is set out here. Shoot me an email if you have any questions about what I've said, and I'd be happy to respond in an email or a call, whatever works. But I am really happy and thrilled to be here today to share with you this information about hiring practices, and hopefully it makes your organizations stronger in the years to come.
Great. Thank you so much, Nicole. Would you maybe be willing to share the slideshow with me, and I can maybe pass it along as well?
Yeah, absolutely.
Perfect. Great. Well, then if there are no more questions, we will wrap up for the day and see everyone next week. So thank you again, Nicole, so much for your insight and expertise here.
Thank you. Take care.